The UN's top court has rejected a request by Nicaragua to order Germany to stop sending weapons and other military aid to Israel. The International Court of Justice in The Hague ruled that legal conditions for making that kind of order simply have not been met. Nicaragua argues that by supplying weapons to Israel, Germany is facilitating genocide in Gaza. Now, during the hearings, the German government said that it had barely exported weapons to Israel since the offensive started following the October 7th terror attacks by Hamas. All right, for some legal analysis now, I'm joined by Sir Geoffrey Nice. He worked at the International Criminal Tribunal for the former Yugoslavia between 1998 and 2006, and he led the prosecution of Slobodan Milosevic, the former president of Serbia. Mr. Nice, it's good to have you with us again. Am I reading this correctly, that the court today said that it looked at the facts, and based on the facts at this time, it cannot give Nicaragua what it wanted?
Completely correct. It's a sort of, in a way, it's a sort of holding judgment. It certainly doesn't achieve for Nicaragua what it wanted to achieve, but it does little else in way of favoring one side or other of this horrible conflict. It did identify two things. First, that Nicaragua can press ahead with its case against Israel, against Germany, if it wishes to, on the basis that Germany may have become involved in the supply of arms for use in what is an unlawful, what may be an unlawful conduct of conflict, but not at this stage sufficient evidence to prove a need for protective measures. And it also left without comment the vulnerability of states generally to ICC and ICJ, International Court of Justice, jurisdiction for example, provision of arms to Israel for its conduct of the war.
Yeah.
So it was a bit of a holding judgment.
Yeah, I want to pick up on that in just a moment, but I just want to be clear. This case continues, and does that mean that the court could eventually rule against Germany at a later stage?
Nicaragua's case against Germany, which alleges breaches of the Genocide Convention by Germany in respect of its provision of weapons, can continue. Whether that will actually happen, I think, is a matter for future consideration, but it can continue. Because Germany tried to have it taken off the list of the court's cases, and the court refused.
What's your read on this, Mr. Nice? Do you think that this is basically, the end of this case?
I don't know whether it's the end of this case, and I'm not sure that I have an overall view, but it leaves states that are supplying weapons to Israel in the position that they know they may be pursued at the International Court of Justice by any other state that's a party to the Genocide Convention, if that other state is able to establish that the subject state is in the possession of knowledge, knowing it knows that its weapons may be used for unlawful conduct of war. So that's one part of the readout. The other part, I think, is that, and this is quite a helpful thing from Germany's point of view, but also from the point of view of other countries, it's really saying don't jump too soon. Could be said of Nicaragua, as I believe it's been said in respect to alleged reflection by Nicaragua of Russian interests, that it's jumped too soon. It's tried with insufficient evidence and almost on emotional grounds to bring this case against Germany. And what we all have to do is to detach ourselves from the high emotions that can be generated by this awful conflict and just look at the evidence. And I think that perhaps the most valuable element of this judgment overall, and for both sides, is that set aside the emotion, look at the evidence. Is there unlawful conflict? If there is unlawful conflict, who's to bear responsibility.
Well, isn't the court doing exactly that? The court today in its ruling said that it noted that Germany had reduced significantly the amount and value of weapons that it has sent to Israel since the October Hamas terror attacks. I mean, as proof that Germany is not trying to arm a country to commit genocide. That's a non-emotional observation, correct?
Well, I found the order pretty thin, both when I listened to it and then when I eventually found it on the website. Mm-hmm. It recites the allegations. Mm-hmm. It recites the history of Germany's provisions of weaponry, both its various licenses that are required, the weapons provided, and the weapons requested to be granted a license, I think a submarine and some other aircraft, I think, for which no licenses have yet been granted. Mm-hmm. And to that extent, it certainly seemed to have given a decision based on Germany's conduct. But it doesn't say it in terms. It simply sets out the evidence that Germany is providing and says, in light of all this, no, there's not enough evidence. And that's why I go back to the original position. I think this is a holding position. Mm-hmm. And in a way, it's quite a clever thing for the court to have done. Because, of course, it can't reverse the earlier decision made in January, brought as a result of what South Africa did. Right. So it respects that. But it doesn't change the position very much. But it warns everyone they've got to honor the Geneva Convention if they're signed up to it, the Genocide Convention, if they're signed up to it.
Let me pick up the case with South Africa. Just to remind our viewers, South Africa is accusing Israel of perpetuating genocide in the Gaza Strip. The court has called on Israel to do everything in its power to prevent genocide. So does that mean that Israel may be found to have committed genocide in Gaza? I mean, is that question still to be answered?
No, it doesn't. And it's understandable that the shorthand in the words of journalists and commentators is that there was a plausible case of genocide established. No. What the court found was that there was a plausible, by the way, the word plausible is not defined. It's a word used by the International Court of Justice, not by other courts. There was a plausible case for finding that the rights of the Gazan people not to suffer genocide were at risk of potentially immediate imperilment. So it was very slightly different, but significantly different from a finding of plausible genocide being committed. That has not been found. And it's very important for listeners and viewers to understand that. And it's the way these proceedings advance, slowly.
I want to ask you, before we run out of time, Mr. Nice, that U.S. media are reporting that the International Criminal Court may issue an arrest warrant for Israeli Prime Minister Benjamin Netanyahu. We don't have much time here. I just want to ask, do you think that that will happen?
It begins to look as though the warrant may be issued. That's very good news. Not because it's particularly issued against Netanyahu. I don't express an opinion about that. But because it shows that the International Court is not going to be intimidated in doing its job in respect of leaders, great, small, supported, and not supported. So to that extent, it's good news. Whether it's going to be issued or not, I don't know, but it's beginning to look as though it's quite likely. And that, I think, is also good news when measured against what may be said about the International Criminal Court, that it has been very slow over the last decade or so to conduct investigations, to say things about the state of Israel. It's been very slow. And now perhaps it's realizing that its reputation is going to be dependent on being seen by the public at large to do its job, regardless of who the alleged offender may be.
Okay. Sir Geoffrey Nice, as always, Mr. Nice, it's good to have you with us. We appreciate your analysis tonight. Thank you.
You're most welcome.
All right, let's talk more about what happened today. I'm joined now by Michael Becker. He's Assistant Professor of International Human Rights Law at Trinity College in Dublin. He's a former legal advisor to a judge at the International Court of Justice. Mr. Becker, it's good to have you with us. You know, the court's president today said that based on the factual information and the legal arguments that were presented, the court concludes that the circumstances are not as such as to require the exercise of its power. Does that mean the court agrees with what Germany was claiming here?
Well, it's not quite as cut and dry as that. For one thing, it's interesting to note this was not a close call for the court. So this was a 15-1 decision ruling against Nicaragua's request here. But what's, I think, significant is that this was a decision that turned on the facts. So we have very little legal reasoning in the court's decision. This really came down to the court finding that Germany, during its presentation earlier this month, had put forward sufficient factual information to really undermine and call into question many of Nicaragua's allegations and accusations, some of which appeared to be based on incorrect information and maybe came off a little bit like exaggerations, which I think didn't play very well in front of the court.
And bearing that in mind, this case, however, is not over, correct?
Absolutely. This was only about seeking what we call provisional measures, so kind of interim relief while the case is pending. And Nicaragua was asking the court to order Germany, among other things, to immediately cease all weapons shipments, arms shipments to Israel. What's quite important here, and this was in your lead-in, part of Germany's defense was to say, well, actually, since at least late October, we have not been sending any significant amount of war weapons to Israel. So Germany, having made that representation to the court, I think it actually does put a constraint on Germany in terms of changing course and resuming that. But you're absolutely right. This was only about provisional measures. The court continues. Germany will have now a chance to challenge the court's jurisdiction and admissibility, which they surely will do. And if it goes ahead, Nicaragua will have the opportunity to put forward a much fuller record that challenges some of Germany's assertions at this stage about the robust framework that Germany has in place to provide oversight over its weapons sales.
So that means Germany could still be found to have facilitated genocide in Gaza, correct?
That's correct. And it's not only about facilitating genocide or failing to prevent genocide, which is probably the slightly lower bar to clear. This is important. This isn't only a case like the South Africa-Israel case. This isn't only about the Genocide Convention. Nicaragua also claims that Germany is in violation of international humanitarian law by doing things or failing to do certain things to ensure respect for international humanitarian law by Israel. So by the idea is that by sending weapons to Israel, you're facilitating violations of international humanitarian law. That's an issue that will remain in the case. And it will now be for Nicaragua to try to show, which they weren't able to do at this initial stage, try to show that all of Germany's representations about how Germany exercises a high degree of due diligence to prevent weapons shipments from being used to violate international law, Nicaragua now has the burden of trying to show that actually, as applied or as implemented, that regulatory framework isn't enough.
Let me pick up on the other case you mentioned with South Africa. South Africa is accusing Israel of perpetuating genocide in Gaza. The court has called on Israel to do everything in its power to prevent genocide. So what does that say to you? Does it say that Israel could eventually be found guilty?
Well, a decision on that question in the South Africa versus Israel case is a long ways away. We now have two sets of provisional measures in that case. So unlike the Nicaragua case where the court rejected that request, the court has twice indicated provisional measures against Israel. And the last time, I think the rhetoric, the language from the court was much stronger, really, deeply concerned that one of the judges refers to all the alarm bells of genocide going off here. So I think we don't know what the outcome is going to be in that case. It's very difficult to prove genocidal intent. It's very difficult to establish genocide at the level of the state. That said, I think that it's probably the case that some of Israel's actions, even since South Africa first filed this case at the end of December, has actually made South Africa's case stronger rather than weakening South Africa's arguments.
Do you think the rulings that we have seen so far, do you think they are going to shape the way that genocide will be defined in the future?
That's a great question. And I think that this case provides an important opportunity for the court to perhaps revisit the way it's approached genocide in the past. And it's also the case that the situation in Gaza raises aspects of the law of genocide that haven't really been litigated in front of an international court before. Right now, for example, there's a lot of attention on the situation of starvation or famine in Gaza and how that might play into a finding of genocide. So this case will almost truly develop the law of genocide, but whether it develops the law of genocide in a way that creates a slightly more liberalized regime or relaxes the very exacting standard to establish genocide or not, that's what we're going to have to watch out for over not only the next few months, but in fact years before there's a determination in that case.
Okay. Michael Becker, we appreciate your time and your analysis today. Thank you.
Thank you.